Gentlemen.
Well, good afternoon. Ken's going to let me go first. My name is Jeff Clayton. I'm the Executive Director of the American Bail Coalition. Happy to be back in Texas again, proud graduate of Baylor University. The Chief Justice came down here and said his guiding principle is that liberty is the norm and that detention is the carefully limited exception, which is, of course, a famous quote from U.S. versus Salerno, 1987, upholding the Federal Bail Reform Act of 1984. But unfortunately, what the Chief Justice didn't tell you is that pretrial detention in 1984 was 24% of all defendants. Today, that number is hovering right around 72%. In other words, detention is the norm. Liberty is the carefully limited exception. And the reason is because when you give the government the power to lock people up with preventative detention, they'll do that. That's why in the new New Jersey system, 44% of all defendants have a motion from a prosecutor demanding that they be locked up and throw away the key. The Maryland Court of Appeals implemented a similar system, bail or no bail. Baltimore City, 23% increase in pretrial detainees in the first year. 2 states this year have rejected the very plan that was posited to be passed last year, 1338, and those would be the states of Idaho and Delaware, which are on complete opposite sides of the aisle. Ferguson, Missouri is another good example where the risk-based system increased the pretrial jail population by 21% in the first year. So the point of this is it could backfire. In other states like New Mexico, it's the exact opposite. They can only detain 5% of defendants because they didn't fund prosecutors to file the motions, which is extremely expensive. And to note the cost, going to a system of preventative detention in California's, which there was a ballot initiative filed yesterday to overturn, will cost in excess of $1 billion. New Jersey's spending $250 to $300 million to implement this system. So the costs are extremely real. And the point that we need pretrial services instead of bail bondsmen is not a fake one. It's a real one. But that means tons of government resources to try to replicate the financial incentives and the work that bail bondsmen do. Plus, they have arrest powers, which the state won't have, and that will fall to law enforcement officers. Risk assessments are definitely proving not to be worth the cost. Thus far, they've not largely reduced pretrial jail populations and have had the effect instead of increasing crime while on bail and failures to appear in court. And let's talk about Kentucky. In a landmark study that's, I believe it's in the Northwestern Law Review conducted by Professor Megan Stevenson, evaluated more than 1 million cases and concluded that Kentucky's use of pretrial assessment had, quote, a trivial decrease in incarceration while increasing crime and failures to appear in court. And this study came out last December, and I've certainly put that in the materials. The other thing is I've been invited to Kentucky to present at the judicial conference because their system is working so poorly, they're thinking about abandoning it and going to a pure no-money bail system. And so I don't think Kentucky's any good example of any good public policy. Other research recently has confirmed, and I can tell you this issue has pivoted 180 degrees since you looked at 1338. This is going to appear in the Stanford Law Review. The professor from George Washington University did a lengthy study of pretrial risk assessment tools, and I'll just read you the quote. Quote, pretrial risk assessment instruments, as they are currently used, cannot safely be assumed to advance reformist goals of reducing incarceration and enhancing the bail system's fairness. Early evidence remains sparse, and risk assessment instruments may yet prove themselves effective tools in the arsenal of bail reform, but they have not done so to date. Shifting to risk-based bail will not necessarily reduce incarceration. Without stronger data practices and open governments, we believe it is likelier than not that these tools will perpetuate or worsen the very problems reform advocates hope to solve. And this is based on research from numerous jurisdictions, and certainly I've provided the link to that study as well. Racial bias. I think we give it short shrift here. Also gender bias. We just say, well, it's objective, so it works better. Well, the concerns about racial bias are real. Within the last month, 115 national civil rights groups, including the NAACP, ACLU, and others, have called for the end of pretrial risk assessments in the United States of America, saying they should no longer be used due largely to concerns of racial and gender bias. In fact, there's not even a settled debate within the academic literature of what method to use to determine if a tool is racially biased. The one being used in Harris County, they deny the error rate balance approach, which triggered this entire wave of opposition, saying that, well, even though we predict that African-American defendants are more likely to be dangerous than their white counterparts, that doesn't matter because we predict equally amongst racial groups getting it wrong somewhere around 30% of the time. So those concerns are real, and I think that entire issue has pivoted since you last considered 1338. Other good research, I think, from Professor Robert Worth of Rice University published a recent study that accused the expansion of risk assessments since 1970 as a major reason for a generational increase in mass incarceration. And the reason is because we treat everyone as risky. There is no redemption. quote, it has been argued that risk assessment tools could help stem the tide of mass incarceration. However, the evidence suggests thus far risk assessment instruments have contributed to expanding the number of people enmeshed in the criminal justice system, encompassing imprisonment, probation, and parole. Other research compares risk assessments to the federal sentencing guidelines and also indicates that they are not a panacea in pretrial justice and will probably not solve the problems we're seeking to solve. Now let's just talk briefly about the praised Texas risk assessment systems that would expand these risk assessments to 254 counties. What we heard today and what the case the governor is concerned about is the judges don't have the information they need. A risk assessment is not information. It's a scoring of the information. And that's what I tell policymakers around the country. The judges don't need the score. They don't need to know that the person has 3 felonies and score it. They need to know what the 3 felonies were. They need to know the facts and circumstances around those 3 felonies. They don't need a score of the 3 felonies. And I think you make a mistake to say we're going to go give judges a score when we could instead just give judges the information and let them score it itself. And I think that would be a huge travesty to spend money to have a computer tell judges how to decide bail rather than giving the information and letting them decide it themselves. I would also say that the decision to employ a risk assessment is one of substantive law and should be made by this legislature and not by the court system, because ultimately these risk assessments are going to be challenged in court, and having a chief justice or judiciary say that they're righteous presents a huge barrier to either prosecutors or defendants in a criminal case challenging them. Finally, this whole idea that we need preventative detention, those who do not learn their history are doomed to repeat it. There's a great article, I didn't put it in the materials, but I'll send it to you. It was published in the Northwestern University Law Journal in 1986, and it's titled Preventative Detention, a Constitutional but Ineffective Means of Crime Control. And what the article points out, and I think what New Jersey proves, is the idea of false positives. And let's look at New Jersey, for example. Their algorithm is calculated to where all of the people that are going to be detained without bail, there's a percent that are going to fail. And that percentage is 45%. In other words, 45% of defendants who we're going to seek detention for are going to fail. So let's just call it half of them. Half of them are going to fail. The problem is when we detain in New Jersey and under a system of preventative detention, we're going to have to detain 10 people to get the 5 because we can't distinguish which 5 are going to do it and which 5 aren't. And to suggest that we can control pretrial crime with preventative detention, I think is generationally wrong. And I think this article predicted that in 1986, as did the dissenter in the Salerno case, Justice Thurgood Marshall. And I would also point out, the final point I would make on preventative detention is, noted federal civil rights professor Daniel Freed, the late Daniel Freed from Yale University, testified against the Bail Reform Act of 1984. And what he said was, what do you know today that the authors of the Federal Judiciary Act of 1789 didn't know then? And the answer is nothing. We have to trust judges to do their jobs. And if we're going to task judges with making a finding that somebody is dangerous moments after they're arrested, for which no trial can exonerate them, then that's just a bad system. And I think that backs up the research of what Robert Worth has said, is that there's no redemption in America, there's no reform. It's you're dangerous, you're always dangerous, and the longer you're in the criminal justice system, the more dangerous you are. And I don't think that's the right public policy for the state of Texas. So thank you for having me today.
I appreciate